All right, we'll be on the record. This is KCR 22-211624, State versus Lori Vallow. Representing Ms. Vallow is Mr. Archibald and Mr. Thomas for the defense. State's here represented by Mr. Wood. Ms. Rawlings is here. Rachel Smith also for the prosecution. I believe Lindsay Blake was intending to appear by Zoom. Has she been let in or appearing? Okay, well, to the extent she can make an appearance there, we'll try to transmit this decision through the Zoom proceeding as well. The court would note as we get started here, there is an order governing courtroom conduct. I would ask everyone to please comply with that order, specifically as it relates to parts 2, C, and D regarding the use of cell phones or electronic devices, that there's no recording permitted throughout these proceedings, either audio or video, and please have your phones in a either silent or off mode so that they don't interfere with any proceedings today. The court was here last week on motions filed just on the eve of trial from the defense. The court took under advisement motions in order to have time to make rulings today, which the court will do in an oral ruling. The motions that the court had under advisement were a motion to compel, which was filed by the defense March 7th, and the state's response March 13th. There was a rebuttal to that filed March 14th, and the court heard argument on that motion to compel. At this time, then, the court is prepared to make ruling on the motion to compel. In essence, the motion asked the court for an order compelling the disclosure of all information that was sought by the defense in a discovery request that was filed in the case on August 9th, 2021. Some procedural history there. There was an order appointing Mr. Archibald on August 6, 2021 as the attorney in this case. There was a first supplemental discovery disclosure provided by the state on August 9th, 2021, notifying the defendant of statements of the defendant. The disclosure also identified what was, quote, defendant's jail phone calls and visits. There was also responses as to statements of co-defendant, which also referenced, quote, defendant's jail phone calls and visits, and the defendant's prior records, and those had been previously provided to the defense on a July 15th, 2021 disclosure according to the state. The court considered the state's response to the request for discovery. There was a notification by John Thomas that the discovery in the above referenced matter was provided to co-counsel Mr. Archibald August 16, 2021 and November 22nd, 2021. In the hearing we had on March 15th, 6 days ago, the counsel for the defense stated unequivocally that the state on Monday, March 13th, had given the defense recordings of jail calls and visits, but also argued that there was no time to fully review those and investigate if anything needed to be investigated. As it relates just solely to the motion to compel, based on the request that any additional items be further disclosed through discovery, the court does find that the state did comply by providing the responses requested through the motion to compel. And so, based on argument and what was represented on the record, the court finds at this time it's not necessary to order any compelling further of discovery, as the state's indicated it's been provided. So the defendant's motion to compel is denied. And I'll mention to counsel, obviously, I've got quite a bit to say here today, and this will be oral rulings which will be preserved on the record. We do have the court reporter here as well as the FTR recordings, and I won't be requesting any orders to be submitted from counsel. The court will take care of the orders that will flow from the rulings made today. The other motions court took under advisement was a motion in limine to exclude late disclosed evidence. The court has gone through that motion in limine to disclose the late disclosed evidence, and In lieu of an oral ruling on that today, the court is going to issue a written ruling which will address the specific items sought to be barred in the motion in limine, and a written ruling will be provided to the parties, should be no later than tomorrow on Wednesday, the 22nd of March. Final motion then the court will consider today is the motion to dismiss the death penalty. That was a motion filed on March 5th, 2023, and seeking dismissal of the state's notice of intent to seek the death penalty that was filed in this case on May 2nd, 2022. The court did determine the notice was timely filed pursuant to Idaho Code 18-4004A. I'll just note at the outset, too, I recognize a late filed motion to provide additional evidence to the court was filed yesterday. I'm aware that that's been filed, and I'll address that at the end of the decision that I've made here now. Going back procedurally then to the motion to dismiss the death penalty, the motion cites 4 bases in support of the argument to dismiss the death penalty in this case. Number 1, media saturation. Number 2, multiple discovery violations by the government. Number 3, an argument that the defendant's mental status should preclude the death penalty. And number 4, an argument regarding the inability of the state to effectively administer the death penalty if the jury decided to impose it. The state filed their objection to this motion on March 13th, 2023. The state argues the motion is not ripe, that media saturation is not a valid ground for the relief sought, that the alleged discovery violations do not warrant the relief sought, that capital punishment is a constitutionally available sentence in Idaho, and that the manner in which the punishment may be administered is not a ripe issue. The defendants then filed their response to that motion March 14th, the following day. So that was a week ago. Contained in the response was a supporting affidavit of Mary C. Goody, who is a defense team mitigation specialist on the defense team. In her affidavit, there were a couple of statements and comments in there. Paragraph 18, she says, quote, "The recent disclosures make reviewing the complete discovery information frankly impossible." Paragraph 19, quote, "Should this additional discovery be allowed, I would be further precluded from conducting my customary and reasonable mitigation investigation into Lori Vallow Daybell's case. Allowing in any of the state's new discovery after the discovery cutoff date prevents me from conducting the type of mitigation investigation which adheres to the prevailing professional norms of practices in death penalty cases." At the outset, this court has considered the arguments in the motion to dismiss the death penalty relating to media saturation, the defendant's mental health, and the ability or inability of the state of Idaho to currently carry out a death sentence. The court notes that also under advisement are motions challenging the constitutionality of Idaho's death penalty statute. Those arguments will be addressed subsequent to the court's analysis of the argument that late disclosed discovery in this case merits a sanction of the dismissal of the death penalty, and this decision will focus on that argument. The court will now review the argument related to the alleged discovery violations in this case. There's a pertinent timeline that the court's considered in the case. There was an indictment returned by a grand jury on May 25th, 2021. The defendant was arraigned on April 19th, 2022. The state timely filed a notice of the intent to seek the death penalty on May 3rd, 2022. Court sent out a amended scheduling order after a January trial had to be continued. And in that order, a pretrial conference was scheduled and held on February 23rd, 2023. At that time, this case was joined for trial with a companion case, State versus Chad Daybell. That's case CR 22-21-1623. And the court ended up granting a severance motion, severing the cases on March 2nd of this year. The court would note that before the severance of the cases, both of the defendants began complaining about the timeliness of discovery disclosures provided by the state, arguing that large volumes of discovery were occurring late in the proceedings, impeding the ability of the defense to prepare for trial. At the February 23rd pretrial conference, defense counsel stated concerns about being prepared for trial due to recent discovery disclosures. Counsel for Mr. Daybell in the companion case stated unequivocally that he would not be ready for trial because of recent voluminous discovery disclosures. This issue again came before the court 19 days ago when the court ordered a severance of the two cases for the trial based on recent disclosures of DNA evidence that led to a determination that the companion case had to be continued to allow for additional DNA testing. Importantly, in that other case, Mr. Daybell waived his right to a speedy trial, and the defendant in this case has not. Last week, on March 15th, the court held another hearing, again largely focused on the issue of discovery disclosures and an argument of the defense that they had received late disclosures past the court-ordered deadlines and that they were now, in fact, prejudiced by those late disclosures. The court took those issues under advisement for ruling at the earliest opportunity we had, which is a ruling made here today. The court reviewed the history of the discovery requests and disclosures in this case. There are three categories relating to the disclosure dates. There are disclosures of discovery that were made before February 27th, 2023, which are deemed timely under the court's scheduling order. There were disclosures made on February 27th, 2023, which were late in that the scheduling order expressly stated that the discovery had to be completed prior to February 27th. And there's a third category of disclosures which occurred in March of this year, which were inarguably late and past the February 27th deadline for discovery. The courts considered the argument of the state as it relates to that February 27th deadline. While the order is clear, the state argues that it was led to believe that the February 27th date was in fact the deadline. In considering this argument, the court determines that the disclosures made February 27th were in fact late, but considers the state's good faith explanation and mitigation when determining whether prejudice has resulted due to the time those disclosures were made. However, the court also must consider that additional disclosures were made well after the February 27th deadline and are inexcusably late. Notably, there were provided to the defense for the first time recordings of jail calls and visits, which include both statements recorded of the defendant and the co-defendant. Still pending out there also are potentially new DNA results, but the disclosures of those 100 plus hours, as it's been represented, of jail phone calls of the defendant and co-defendant were clearly past the deadline. So the court now must consider, pursuant to Criminal Rule 16E2, well, I'll cite a case here, which is State versus Matthews, 124 Idaho 806. And that says, pursuant to Idaho Criminal Rule 16E2, and I'll note that's now Rule F2, the rules have changed. The court is authorized to impose sanctions for discovery violations. See State versus Merrick, 112 Idaho 860, 1987 case. The choice of an appropriate sanction for failure to comply with a discovery request is within the discretion of the trial court, and the trial court's exercise of that discretion is beyond the purview of a reviewing court unless it has been clearly abused. And that's, again, the State versus Matthews case, 124 Idaho 806. Courts reviewed Idaho Criminal Rule 16K, which cites to orders for discovery. If a party has failed to comply with a request for discovery under this rule, the court, on motion of a party, may, number one, order a party to permit the discovery or inspection. Number two, prohibit the discovery of part or all of the information, evidence, or material sought to be discovered. Or number three, enter such other order as it deems just under the circumstances. So the court does have a statutory or a rule-based and case-based precedent for imposing any sort of sanction as a result of discovery violations. As an initial determination here, this court does find that there have been discovery violations in the case. The defense argues there have also been Brady violations. The court has reviewed the record and determines that at this time there's no indication that the state has violated either Criminal Rule 16A, which requires mandatory disclosures, or Brady, as there's no evidence that tends to negate the guilt of the accused as to the offense charged, or that would tend to reduce the punishment of the offense. No evidence of that nature has yet been identified specifically. The problem here is a timing problem. The problem here is that both parties cannot be certain whether or not there is exculpatory evidence or mitigation evidence within the late disclosed discovery. The defense argues that they cannot review the late disclosed evidence because there's simply not enough time remaining before trial to do so. The state conceded at the hearing on March 15th that even the prosecution likewise would be unable to complete the review of all discovery before trial. The court cannot and will not engage in speculation that the late disclosed discovery does not contain any exculpatory or mitigating evidence. If the final discovery disclosures had been submitted by the state to the defense on February 27th, and that was the end of the disclosures, it would be difficult for the court to determine that prejudice would arise from potentially a one-day miscalculation. However, even more discovery, and a significant amount, was further disclosed even later. On March 7th, just 14 days ago, a motion to compel was filed by the defense requesting further disclosures of information previously requested by the defense going back to a 2021 filing. In response, the state produced a supplemental discovery disclosure on March 13th, 2023, producing those, what I'll refer to as jailhouse recordings. The parties have represented to the court that over 100 hours of previously undisclosed recordings were provided to the defense. The state concedes that this late disclosed discovery was due to, quote, an oversight within the offices. In order to determine if a discovery sanction is warranted, the court has to consider whether there is in fact now prejudice. A Brady or Youngblood is another case. Analysis is not required to reach that decision here, as the fundamental consideration is the right of the defendant to meaningfully prepare their defense and the duty of the state to comply with court-ordered discovery deadlines. As has been argued throughout this case, death is different. Here the defense argues there is actual prejudice due to the late disclosed discovery and that it is substantial and material. The court has considered the arguments of Mr. Archibald. Mr. Archibald urged the court to consider that he typically receives discovery in a timely manner when dealing with the prosecution in other cases and does not have these discovery-related issues. And the court, based on my experience, I agree with that assertion. I've dealt with Mr. Archibald in hundreds of felony cases, including other murder cases. I can't remember a single case where Mr. Archibald filed a motion to compel or argued for a discovery sanction until this case. Mr. Archibald has established a pattern of credibility with the court that I consider when hearing his arguments that there is in fact prejudice. Likewise, this court has also dealt extensively with both Mr. Wood and Ms. Blake in hundreds of felony cases. And I find that both Mr. Wood and Ms. Blake are honest prosecutors and forthright in the duties they undertake as prosecutors, and I have no reason to question the integrity of the prosecution in this case. As has been demonstrated in this case, they've continued to disclose discovery even when they knew it was beyond the deadline, because they have followed their ethical responsibilities in this case, as they do in all of their cases, in my experience. Upon weighing the arguments of counsel and considering the record, the court must determine here that the defense has in fact demonstrated material prejudice resulting from late disclosures. The prejudice has occurred because of the proximity of the trial the volume of the discovery, and the inability of the defense to adequately review that discovery before trial begins. In a case called U.S. versus Rivera Clemente, a federal court held that the failure of the government to fully disclose all discovery resulted in prejudice. The court further stated, quote, moreover, in a death penalty case where the stakes are so high, a smaller quantum of prejudice may justify a sanction. And that also cites a different case, Lopez Matias, 522 F. 3rd, 154. Having determined that prejudice has resulted due to the late disclosed discovery, the court must next consider what course of action, if any, is necessary. First, with the defense having timely raised the issue, the court determines that if I were to fail to address this discovery issue, I believe this case would inevitably be reversed on appeal if there was a capital conviction. With the defense assertion of prejudice, the court must determine what is an appropriate remedy. Here, because the court has found or has not found any willful conduct on the part of the state, the court is not primarily concerned with any sort of sanction or punishment. What the court must address is an appropriate remedy to try to mitigate the prejudice that has been caused by the late disclosures. Ordinarily, a logical remedy would exist here, and that would be a continuance of this trial. This has been proposed by the state as one solution, and the state has proposed to mirror a continuance in the companion case of the Chad Guy Daybell's case, the 1623 case. However, here, that's an option that I can't consider, because in this case, the defendant has unequivocally asserted her right to a speedy trial. In determining whether speedy trial is violated, one of the major factors is the reason for the delay. The reason for the delay here rests on the state and can't be counted against the defendant to justify a delay of her trial in this case. If I were to delay this case based on an issue caused by the state, I believe that would violate her fundamental and constitutional right to a speedy trial. On that issue, it's been brought up before, and I would caution the defendant that her attorneys have also cautioned her that by insisting on going forward with the trial now, knowing there's additional evidence they are not prepared to address, that's a risk. And the risk, I believe, has been discussed by counsel and by the defendant, and the decision as to whether or not to continue forward without a continuance is a decision only the defendant, with the competent advice of her counsel, can make. The issue's been raised before, and again, there's never been a waiver of speedy trial, so we're scheduled to start with jury selection next week, and that's when we're going to do this trial. The court sees then the remaining options then as either somehow sifting through this evidence to determine what should or could be excluded. I could also follow the defense recommendation of just carte blanche excluding significant portions of the state's case as a sanction, and I've considered that. The court also finds that given the statements of both the defense and the state, it would be impractical at this late stage, with trial starting next week, to be able to go through this evidence in a piecemeal fashion to determine what comes in or what would be excluded. There's simply not enough time to go through that exercise. The court also finds the defense request to exclude numerous witnesses and much of the state's evidence would be an unreasonably harsh sanction, denying the state of its right to bring the defendant to trial on evidence that's been previously disclosed. So that means there are two remaining options to consider: striking the death penalty or dismissing the case. The court determines that dismissing the case would again be too severe of a sanction here, given that the court finds the state has in good faith attempted to disclose all discovery, and with a clear determination here that the state has not acted in any way in bad faith. The court's considered further the state's objection as it relates to an argument that this issue is not ripe to be considered at this time, that perhaps the court should wait until a verdict comes in to determine whether or not the death penalty should still be instructed to the jury in this case. I don't find that to be a persuasive argument. I think it is a ripe issue that's before the court now and needs to be determined before trial begins. There's a case, I'll cite, United States versus McGriff, 427 F. Sup. 2nd, a 2006 New York case, says, moreover, there are practical reasons weighing against the post-trial assessment to conduct a capital case. Only to strike the death penalty notice afterwards would be a colossal waste of time, effort, and expense for both litigants and the courts. Finally, then, the court considers the defense argument that the death penalty should be stricken as a discovery sanction in this case. The court notes that it is the sole province of the prosecution to exercise their discretion in determining what charges to file, and in this case, whether a notice of intent to seek the death penalty under Idaho law is warranted. Being mindful of that, the court has sought to consider any other reasonable alternative to interfering with that prosecutorial discretion. As previously mentioned here, all other options have been considered before determining whether it would be an appropriate sanction to strike the death penalty. First, and again, the court would note that there's a heightened level of scrutiny and due process protection afforded a defendant in a death penalty case. The statement death is different has been cited many times by the defense in this case, and it is in fact a legal maxim coming out of a federal case called the Furman case. The U.S. Supreme Court summarized in some of these decisions another case called Sparkling versus Florida, and they noted that in post-Furman jurisprudence, continuing to recognize that, quote, death is different. In the 12 years since Furman, quote, every member of this court has written or joined at least one opinion endorsing the proposition that because of its severity and irrevocability, the death penalty is qualitatively different from any other punishment and hence must be accompanied by unique safeguards to ensure that it is justified response to a given offense. The U.S. Supreme Court has on occasion relied on this difference as the basis for upholding procedures in death cases that are not required in other cases. There's other sites that cite to a heightened fairness and heightened reliability standard that comes along with capital cases, and also a fairness in fact finding. And that would be, for example, the Reed versus Convert case. In that case, the U.S. Supreme Court held that, quote, in capital cases, the balance of conflicting interests must be weighed most heavily in favor of the procedural safeguards of the Bill of Rights. And in a different context, the U.S. Supreme Court in Gardner versus Florida held that due process was violated when the death penalty was imposed on the basis of a confidential informant, which was not disclosed to the defendant or his counsel. So the case law from the United States Supreme Court is clear that, in fact, death is different. The court here has to consider whether there is any precedent in Idaho for this proposed sanction. While the state of Idaho, there isn't in the state of Idaho. I'll just state I haven't found any case where this has been considered or ruled on. However, as I mentioned, the sanction has been recognized and upheld in other jurisdictions, including federal courts, and they've recognized it as an appropriate remedy. There are reported cases in other jurisdictions where courts have determined the striking of the death penalty to be an appropriate sanction. Notably, in the federal system, there's a different procedural mechanism required of the government to go forward with the death penalty, and this procedure differs from Idaho. Some of the federal cases detailing why the death penalty was stricken as a sanction explain a failure of the government to comply with that procedure. In those cases, the court discusses a showing of prejudice as a threshold, quote, to bar the government from seeking the death penalty. And that's from a case U.S. versus Rivera Clemente. The rationale, however, behind both that federal procedure and the issuance of a sanction would apply to this case. Some of the quoted language from that United States versus Rivera Clemente case, which is cited DPR September 19th, 2012, that stated that part of the citation there, we agree that the prosecutor's failure to provide timely and full disclosure of all statements has caused prejudice to the defendants. And then they stated that in a death penalty case where the stakes are so high, a smaller quantum of prejudice may justify a sanction. And in that case, the sanction was the striking of the death penalty. In this case, the trial court here, I'd cite to a case, State versus Morales, which is a Connecticut case, 232 Connecticut 707, a 1995 case. The trial court should not be faced with the Hobson's choice of either dismissing all criminal charges or denying any relief whatsoever to a criminal defendant who possibly has been prejudiced as a result of the negligence of the state. Instead, the trial court should determine the appropriate remedy in an exercise of its discretion. And then quoting another case, State versus Tiedemann, 162 P3rd 1106, which is a Utah case. The touchstone for the balancing process is fundamental fairness. If the behavior of the state in a given case is so reprehensible as to warrant sanction, a sanction might be available even where prejudice to the defendants is slight or only speculative. If prejudice to the defendant, on the other hand, is extreme, fairness may require sanction even where there is no wrongdoing on the part of the state. In between these extremes, we have no confidence that trial judges can strike, or we have confidence that trial judges can strike a balance that preserves defendants' constitutional rights without undue hardship to the prosecution. So that case says to look at weighing out the balance of prejudice versus any misconduct of the state. And again, I haven't found here any misconduct of the state. However, procedurally, disclosures were late and deadlines were missed. On weighing the facts of this case then against the rights of the defense to have an objectively reasonable time to prepare for a death defense, the court determines that the late disclosure of discovery has materially prejudiced that right. The court also notes that this is not the result of a single discovery violation, but rather the cumulative effect of a deluge of discovery coming too close to trial, culminating in a large discovery disclosure a day after the scheduling order mandated, and finally even more discovery that was not provided to the defense until, according to the record, March 13th. The defense cannot be required to review that quantity of new discovery only 2 weeks before jury selection begins. This has prejudiced the defense. I've cited the affidavit of the mitigation person who has said unequivocally they simply cannot have time to prepare and go through for mitigation the late disclosed discovery. Thus, considering everything, the court is required to fashion a remedy that honors the rights of the parties, the fundamental right to a fair trial, and the right of the state to bring to trial those who are accused of a crime. In balancing these rights, the court concludes here that as an appropriate discovery sanction, the state will be precluded from seeking the death penalty at trial, and the state's May 2nd, 2022 notice of intent to seek the death penalty will be stricken. To be clear, the court does not impose this sanction to penalize the state, but rather to ensure the constitutional right of the defendant is protected, allowing for a reasonable defense to be prepared for this trial. In addition, this court will keep under advisement any further objections that may be lodged in the form of motions in limine that will come either before or during trial to consider whether any late disclosed evidence should be excluded in an attempt to remedy the prejudice that may have resulted from these late disclosures. Finally, a couple of points on that decision. There was a late filed emergency motion yesterday that related to this. The court had reached this determination and determined this to be the appropriate remedy prior to reviewing that, and in fact did not consider any of the issues raised in yesterday's pleading in making this determination, and I'll consider that pending motion moot. I'll also note that the ruling here applies only in this case against Ms. Vallow, the 1624 case, and in no way impacts or affects the companion case 1623, because that defendant has been provided additional time to prepare for trial and to review additionally disclosed discovery. So it has no impact on that case. So with that, that concludes the court's oral ruling on the motion to strike the death penalty. Granting that, the court will issue an order to that effect. The court will also be issuing orders that relate to the constitutionality of the death penalty motions that are pending, which will be resolved in orders submitted either today or tomorrow. The court will be available to counsel up until Thursday here. After that, I'll be in Boise for the getting ready to commence trial next Monday. And if counsel needs to reach out in terms of any administrative or planning procedures that change as a result of this decision, I'll do my best to make myself available. That will conclude the ruling for today, and court will be in recess.
All right.